This is the first in a series of 5 videos on rights and safeguards for an accused person as contained in procedural criminal law. Read that to mean the ACJA, the ACJL, the CPA, and the CPC. The first video will treat rights and safeguards for an accused person with respect to searches and search warrants in the ACJA, ACJL, CPA, and CPC. The second video will treat rights and safeguards for an accused person with respect to criminal summons and public summons in the ACJA, ACJL, CPA, and CPC. The third video will treat rights and safeguards for an accused person with respect to arrests and warrants of arrests in the ACJA, ACJL, CPA, and CPC. The fourth video will treat rights and safeguards for an accused person with respect to arraignment in the ACJA, ACJL, CPA, and CPC. The fifth video will treat rights and safeguards for an accused person with respect to accusation and conviction in the ACJA, ACJL, CPA, and CPC. The ACJA recognizes that even if someone, whether he be a resident or a manager, may not be accused of a crime, but his or her property, place, premises, or thing is suspected to be complicit in an alleged crime, then the police is empowered to use reasonable force to access the place if such a person is uncooperative or if free entry is denied. Section 149 subsection 2 of the ACJA. This aligns with Section 35 subsection 1 of the 1999 Constitution as amended, which details the constitutional or national jurisdictional right to personal liberty. The ACJL recognizes that even if someone, whether he be a resident or a manager, may not be accused of a crime, but his or her property, place, premises, or thing is suspected to be complicit in an alleged crime, then the police is empowered to use reasonable force to access the place if such a person is uncooperative or if free entry is denied. See Section 109 subsection 2 of the ACJL of 2011, which deals with search warrants, but compare with Section 8 of the ACJL 2011, which deals with arrests. This aligns with Section 35 subsection 1 of the 1999 Constitution, which details the constitutional or national jurisdictional right to personal liberty. The CPA recognizes that even if someone, whether he be a resident or a manager, may not be accused of a crime, but his or her property, place, premises, or thing is suspected to be complicit in an alleged crime, then the police is empowered to use reasonable force to access the place if such a person is uncooperative or if free entry is denied. See Section 112 subsection 2 of the CPA, but compare with Section 8 of the CPA. This aligns with Section 35 subsection 1 of the 1999 Constitution, which details the constitutional national jurisdictional right to personal liberty. The CPC recognizes that even if someone, whether he be a resident or a manager, may be accused of abduction or unlawful confinement, then a court can order law enforcement to use necessary force to produce the detainee before it. See Section 77 subsection 2 of the CPC, but compare with Section 34 subsection 3, 34 subsection 4, and Section 79. This aligns with Section 35 subsection 1 of the 1999 Constitution as amended, which details the constitutional national jurisdictional right to personal liberty. The CPC recognizes that a female impoder who is not necessarily an accused person, which means that law enforcement has no intention of arresting her, but happens to occupy an apartment that law enforcement is interested in searching, has a right to advance notification of the intention to search such an apartment and to be afforded time and space to withdraw from the apartment in advance of such a search. Section 79 of the CPC. Which section of the 1999 Constitution as amended does this align with? The CPC recognizes that a female accused has a right to dignity and privacy. This explains why it mandates that if a search is to be conducted on the body of a woman, only another woman is authorized to do so, and also that such a fellow woman must conduct her search of her fellow woman decently. Section 82 of the CPC. This aligns with Section 34, Subsection 1 of the 1999 Constitution as amended, which details the constitutional national jurisdictional right to the dignity of the person, and Section 37 of the 1999 Constitution as amended, which details the constitutional national jurisdictional right to privacy. The CPC recognizes that property rights are sacrosanct, and that is why it authorizes the right of the occupant of any place searched or some person on his behalf to be physically present during a search and to request for and receive an inventory of the items responsive to the search, which law enforcement intends to take away. Section 80 and 81 of the CPC. This aligns with Section 36, subsection 6A of the Constitution, which details the constitutional national jurisdictional right to be informed of the crime alleged. Section 36, subsection 6B, which details the constitutional national jurisdictional right to adequate time and facilities for defense, and Section 43 and 44, which details the constitutional national jurisdictional right to acquire immovable property and right to freedom from the indiscriminate takeover of movable and immovable property except by lawful means. The ACJA recognizes that if a person who happens to be the subject of a search warrant is a female, then she has a right to withdraw from the building to be searched if it is her custom or religious practice to be screened from men or strangers. Section 149, subsection 6 of the ACJA. This aligns with Section 34, subsection 1 of the 1999 Constitution as amended, which details the constitutional, national, jurisdictional right to the dignity of the human person. The ACJA recognizes that the person who happens to be the subject of a search warrant has property rights. And this explains why the person authorized to execute the search warrant is duty-bound to generate an inventory of seizures from the person of the suspect. The inventory of seizures should be signed or sealed by the following: the person to whom the search warrant is addressed; 2. The person executing the search warrant; 3. The witnesses. A witnessed copy of the inventory of seizures must be given to the person whose property is searched. Section 149, subsection 5 of the ACJA. This aligns sections 43 and 44 of the 1999 Constitution as amended, which details the constitutional national jurisdictional right to acquire immovable property and the right to freedom from the indiscriminate takeover of movable and immovable property except by lawful means. The ACJA recognizes that the person who happens to be the subject of a search warrant has a right to be informed of the crime alleged, as well as a right to adequate time and facilities for defense. This can be deduced by its allowing the person to whom the search warrant is addressed to provide at least 2 witnesses to observe the search, unless the facts of the case so dictate otherwise. Then the court or justice of the peace may direct the search to be conducted in the absence of witnesses. Section 149, subsection 4 of the ACJA. This aligns with Section 36, subsection 6A of the 1999 Constitution as amended, which details the constitutional national jurisdictional right to be informed of the crime alleged, and Section 36, subsection 6B, which details the constitutional national jurisdictional right to adequate time and facilities for defense. The combined effect of Section 35, subsection 3, which details the constitutional national jurisdictional right to notification in writing within 24 hours in a language he understands why he has been arrested or detained, and Section 36, subsection 6A, which details the constitutional national jurisdictional right to be informed of the crime alleged, may explain the requirement that information in writing is a requirement that must be met by a person seeking to procure a search warrant, as contained in Section 144, subsection 1 of the ACJA. The combined effects of Section 35, subsection 3, which details the constitutional national jurisdictional right to notification in writing within 24 hours in a language he understands why he has been arrested or detained, and and Section 36 subsection 6A, which details the constitutional national jurisdictional right to be informed of the crime alleged, may explain the requirement that information in writing is a requirement that must be met by a person seeking to procure a search warrant as contained in Section 104, subsection 1 of the ACJL. The, the combined effects of Section 35, subsection 3, which details the constitutional national jurisdictional right to notification in writing within 24 hours in a language he understands why he has been arrested or detained, and Section 36, subsection 6A, which details the constitutional national jurisdictional right to be informed of the crime alleged, may explain the requirement that information in writing is a requirement that must be met by a person seeking to procure a search warrant as contained in Section 107, subsection 1 of the CPA. The combined effects of Section 35, subsection 3, which details the constitutional national jurisdictional right to notification in writing within 24 hours in a language he understands, why he has been arrested or detained, and Section 36, subsection 6A, which details the constitutional national jurisdictional right to be informed of the crime alleged, explain the requirement that information in writing is a requirement that must be met by a person seeking to procure a search warrant as contained in Section 74 of the CPC. Section 35, subsection 3 details the constitutional national jurisdictional right to notification in writing within 24 hours in a language he understands why he has been arrested or detained is the reason why a search warrant is written and not oral. Can you find the sections of the ACJA, ACJL, CPA and CPC that supports this assertion? One of the general rules of search of premises is that without a search warrant, any search of premises is unlawful. On the other hand, if there is a search warrant, then the search of such premises is lawful. In other words, whether someone is an accused or not, he or she reserves the right to request for a search warrant to be presented ahead of or before law enforcement can conduct a search of or on his or her premises. The second general rule is that the power of search of a place or premises also includes the power to arrest a person or persons therein. This aligns with Section 37 of the 1999 Constitution as amended, which details the constitutional national jurisdictional right to privacy, and Section 56 subsection 6A, which details the constitutional national jurisdictional right to be informed of the crime alleged. The CPC recognizes that an accused has a right to the execution of a search warrant in the presence of at least two witnesses. Section 78 of the CPC. Which sections of the 1999 Constitution as amended support this accession.